Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Greetings, everybody. I hope you're all enjoying your long weekend and are having a happy Valentine's Day. I know I am, with a mini trip to Sequoia National Forest, so this episode is hitting the road. The trees are large. And in that spirit, there are 7 cases this week, including a whole bunch on asylum and related relief. And make sure you listen through to the 8th Circuit case towards the end. It's an important one on particularly serious crimes and mental health. Also, thank you to attorney Tamara Jezik, who emailed me this week to tell me that the Portillo Flores v. Barr case, an adverse asylum case published by the 4th Circuit and discussed on episode 19 of the podcast, has been vacated by the 4th Circuit and that the court will go en banc on the case. Let's see if some good law can get made. Thanks for the heads up, Tamara. And with that, let's go to the 4th Circuit. First is Diaz de Gomez v. Wilkinson, published by the 4th Circuit on February 8, 2021. This is a case about the nexus requirement under asylum law, and it appears to be an indirect shot at then-acting Attorney General Rosen's Matter of A.B. decision, published just last month, which of course was a direct shot at the 4th Circuit. Shots fired. Also a word of warning, unsettling facts in this one. Miss Diaz de Gomez is a school teacher from Guatemala who entered the U.S. and applied for asylum in 2015. As the basis for her claim, she submitted and testified that in November 2008, she and her husband and other family members witnessed a mass killing conducted by Los Zetas, a Mexican gang operating in Guatemala. The gang threatened to kill the couple multiple times. First, the threats were designed to warn them what would happen to them if they reported what they had seen. But later, Los Zetas threatened to kill Miss Diaz de Gomez's husband if he didn't work for the gang. The husband fled to the U.S. in 2010, after which the gang tried to recruit Miss Diaz de Gomez's brother. When he refused, Los Zetas crashed a car into his moped while Miss Diaz de Gomez was also riding on it with him. Los Zetas then kidnapped the brother, beat him severely, cut off part of his tongue, and eventually, in July 2015, murdered him. After that, Los Zetas turned on Miss Diaz de Gomez herself. They wanted her to traffic drugs because a teacher wouldn't be suspected. They threatened her, followed her, extorted her parents, and waited outside her school. She reported many of the threats over the years, but the Guatemalan police took no action. Following a final particularly egregious death threat, she fled to the U.S. In removal proceedings, an immigration judge and the BIA found her credible, but denied asylum, finding she couldn't establish that she was harmed or feared harm on account of a protected ground, namely, her membership in the particular social group consisting of her nuclear family. the Fourth Circuit reversed. It first reiterated that, quote, death threats qualify as past persecution, end quote. I like where this is going. Then, ignoring now former Acting Attorney General Rosen's contrary beliefs, the Fourth Circuit relied upon its prior precedent in Crespin-Valladares to hold that when it comes to family-based nexus or any nexus analyses, quote, in conducting our review, we ask whether the evidence showed that Diaz de Gomez's family affiliation was one central reason why she, and not another person, was threatened, end quote. Recounting the timeline of events against Ms. Diaz de Gomez and her family, the Fourth Circuit believed it clear that her family membership was a central reason for her being targeted. And here's the kicker to remember circuit-wide. Quote, the fact that the gang sought to recruit Ms. Diaz de Gomez and her family members does not preclude a finding that her familial ties were another central reason that she was persecuted by the gang, establishing the required nexus, end quote. Emphasis in the original. The Fourth Circuit also reversed the immigration judge and the BIA's finding that Ms. Diaz de Gomez had failed to establish that the Guatemalan government was unable or unwilling to protect her because, quote, evidence of widespread gang influence and corruption in the judicial system, together with an applicant's credible testimony, can be sufficient to establish the government's inability or unwillingness to offer protection, end quote. No requirement there that the applicant must show that she can't relocate in her country, as former Acting Attorney General Rosen believes is required. So, Ms. Diaz de Gomez's case gets remanded. Congratulations Pamela P. Keenan of Raleigh, North Carolina, for a great win for your client and for asylum seekers everywhere. Two more things on Attorney General decisions. Although the Fourth Circuit didn't expressly cite to matter of AB II, which is, after all, only a month old, it did hold that in this case, quote, the board's contrary conclusion is an excessively narrow reading of the nexus requirement that is not supported by our precedent, end quote. And that excessively narrow reading seems pretty similar, if not identical, to the one Acting Attorney General Rosen used in matter of AB II. I'd make that argument everywhere. Finally, in a footnote, the Fourth Circuit recognized that Attorney General Barr tried, in matter of LEA II, to narrow the circumstances whereby a family-based particular social group can succeed. But the Fourth Circuit did not address that case because the BIA didn't rely upon that decision. The Fourth Circuit did, however, note its, quote, long-standing precedent holding that a person may seek asylum on the basis of their familial ties, end quote. And the Fourth Circuit could have denied or remanded this case based on matter of LEA II, if it, or oil, had wanted to. Hate to guess at these things, but if I'm a betting man, I'd say matter of LEA II has a high bar to overcome if it is to be relied upon in the Fourth Circuit. And that is Diaz de Gomez v. Wilkinson. Next, we have Macedo Templos v. Wilkinson, published by the Ninth Circuit on February 9, 2021. This case is sticking with asylum and related relief, including particular social groups and torture convention protection. And there are pretty unpleasant facts in this one, too. Mr. Templos is from Mexico and applied for asylum after, he claimed, his family was threatened and extorted by unidentified criminals as a result of the family's successful clothing business. He received threats from 2000 to 2009, was beaten by police officers, had his home shot up, and had to pay a ransom to rescue his daughter from kidnappers. All of this, he believes, was linked to the criminals that were extorting him due to the ownership of his business. He reported some of this to the police, but he never pressed charges. The immigration judge and the BIA denied asylum due to Mr. Templos' failure to file within 1 year of entering the U.S., and then denied withholding of removal primarily based on nexus, from Mr. Templos' failure to establish that his proposed particular social group actually qualified as a protected ground. The Ninth Circuit affirmed, holding, quote, the record does not include evidence that Mexican society perceives wealthy business owners as a distinct group, end quote. The Ninth Circuit also held that that group is not immutable and that it lacks particularity. In making that latter finding, the Ninth Circuit relied on matter of WGR, which, remember, remains good law in the Ninth Circuit, contrary to the Fourth Circuit's holding last week in Amaya v. Rosen. The Ninth Circuit also held that Mr. Templos had failed to establish that he was targeted because of his membership in the group Wealthy Business Owners, rather than purely criminal reasons. However, in the underlying case, the IJ and the BIA also denied Convention Against Torture protection, and here the Ninth Circuit remanded. See, the IJ accepted Mr. Templos' testimony that Mexican police had attacked him, but it seemed that the IJ and the BIA reasoned that those police were not acting in an official capacity and were instead, quote, rogue officials, end quote, thereby precluding cat protection. But such a finding directly contradicts the Ninth Circuit's recent decision in Barajas-Romero v. Lynch, and for that matter, Attorney General Barr's own decision in matter of OSAF last year. Not necessarily criticizing the BIA, as both of those decisions were issued after the BIA's decision in this case, but they exist now, so remand. The Ninth Circuit also noted that contrary to the BIA's holding, for cat purposes, it is irrelevant whether, quote, Mexican authorities have any specific interest in harming, end quote, Mr. Templos. It's only relevant that they do, or acquiesce to it. The Ninth Circuit therefore remanded for further cat analysis. Congratulations, Attorney Kevin Block, for petitioner. You are the second best cat attorney I've seen on the internet this week. I'm sorry, everybody, but seriously, how could I not? Just 2 observations. Judge Bea concurred to make clear his belief that the immutability component in the majority's particular serious crime analysis is, quote, erroneous dicta, end quote. So use that if it helps your case. And finally, might Mr. Templos have had better luck if he had argued that his family membership, rather than wealthy business status, was a central reason for his targeting? See e.g. Diaz de Gomez v. Wilkinson that we just discussed? And their publication, one day apart but with vastly different results, is certainly worth noting. The case is on remand, so I guess it can't hurt to try the argument. And that is Macedo Templos v. Wilkinson. The second Ninth Circuit case this week is Santos-Ponce v. Wilkinson, published by the Ninth Circuit on February 10, 2021. More asylum, everybody. Mr. Santos-Ponce is 16 years old and he's from Honduras. His uncle was murdered by gangs, and he was sent to the U.S. by his grandma, apparently out of fear of the gangs, and to reunite with one or both of his parents. He applied for asylum and related relief shortly after entering the U.S., based on the following 2 particular social groups. 1. The Santos-Ponce family, who have been victims of gang violence. And 2. Minor Christian males who oppose gang membership. The IJ and the BIA denied asylum, withholding of removal, and cat protection for a bunch of reasons. The Ninth Circuit affirmed the agency. It noted that whether an asserted particular social group meets the legal standard of a particular social group is a question it reviews de novo. It then held that, quote, minor Christian males who oppose gang membership is not sufficiently particular or socially distinct, end quote. This is because the record, at least in this case, quote, does not compel the conclusion that Honduran society would distinguish between a young Christian male who resists gang recruitment and any other young man who seeks to avoid gang membership, end quote. But if your record does establish that distinction, practitioners, make the argument and make it forcefully. As to Mr. Santos-Ponce's second family-based particular social group, quote, the record does not contain any evidence that his uncle's membership in the Santos-Ponce family was one central reason or even a reason that the gang killed him, end quote. And in any event, Mr. Santos-Ponce's family members continue to live in Honduras. Again, pretty case-specific facts. The Ninth Circuit, like the Fourth Circuit earlier in the episode, also left open for another day matter of LEA II. Why doesn't anyone want to touch this case? President Biden, Judge Gregg is able and willing. Finally, the Ninth Circuit denied cat protection. Not much else here, but this case is very fact-specific. So if the facts of your case create stronger arguments for either particular social group, make them. And that is Santos-Ponce v. Wilkinson. Continuing on, we have Zaruma-Guaman v. Wilkinson, published by the First Circuit on February 9, 2021. This case is about, you guessed it, asylum and adverse credibility. Mr. Zaruma-Guaman is from Ecuador and entered the U.S. without authorization in 2014. He was quickly apprehended, swore in a record of sworn statement that he did not have a fear of returning to Ecuador, and was ordered expeditiously removed. But a few days later, while in detention and before his removal, he expressed a fear of return and provided many reasons for his fears. An immigration officer must have found that he had a credible fear of persecution because DHS initiated removal proceedings and placed him before an immigration judge for him to pursue his claim. The IJ ultimately denied asylum and related relief based on an adverse credibility finding, mainly relying on Mr. Zaruma-Guaman's inconsistent testimony between his sworn statement and his direct testimony, and between his direct testimony and DHS's cross-examination, about whether he had reported the abuse that he allegedly suffered on account of his indigenous ethnicity to the Ecuadorian police. The BIA affirmed. Applying substantial evidence review to the adverse credibility finding, the First Circuit affirmed. It stated that, contrary to Mr. Zaruma-Guaman's arguments on appeal, there were many inconsistencies during his testimony, and they were all, quote, stark. The First Circuit noted its standard for reviewing such issues as whether, quote, the inconsistencies are of a type and kind that substantially support the IJ's adverse credibility determination, end quote. Here they were. And according to the first, an IJ does not need to make an express finding about demeanor when sufficient inconsistencies have been identified. Finally, the First Circuit rejected Mr. Zaruma-Guaman's argument that the IJ should not have relied upon the DHS sworn statement made during the initial detention, holding that the sworn statement, quote, bore sufficient indicia of reliability, end quote. And this is because Mr. Zaruma-Guaman was put under oath at the time, and it was signed by a DHS officer who witnessed the sworn statement. Notably, the First Circuit rejected Mr. Zaruma-Guaman's argument that the sworn statement was inadmissible because he hadn't signed it, holding that a non-citizen's refusal to sign the statement doesn't go to admissibility, but does, quote, go to its weight, end quote. Mr. Zaruma-Guaman, therefore, did not succeed in his case. I like that last part about the weight that an IJ should or should not accord unsigned DHS records of sworn statement, but that's about all we've got here. And that is Zaruma-Guaman v. Wilkinson. Next, we have Shazi v. Wilkinson, published by the Eighth Circuit on February 11, 2021. This case, wait for it, is not really about asylum-type issues. Rather, it's another case about particularly serious crimes from the Eighth Circuit. Back-to-back weeks, Eighth Circuit, and back-to-back wins for non-citizens. Mr. Shazi is from Iraq and was a member of the National Iraqi Democrats, an organization that assisted the United States and Allied forces in their effort to overthrow Saddam Hussein in the mid-1990s. In this role, Mr. Shazi obtained intel on Saddam's biological weapons, and due to his work, he was extracted to the U.S. by the U.S. government and admitted into the U.S. as a refugee in 1996. It seems like he saw some horrible stuff, leaving him with PTSD, depression, and anxiety. And in 2007, he was convicted of making terroristic threats and assault in the 5th degree. Then in 2011, he was convicted of malicious punishment of a child and felony domestic assault. He was placed in removal proceedings where an IJ found that the crimes made him removable under the aggravated felony and crimes of child abuse provisions of the INA, but granted him withholding of removal from Iraq. So Mr. Shazi essentially got a second chance. But then in 2016, he was again convicted of making terroristic threats in violation of Minnesota Statute Section 609.713, Subdivision 1, and domestic abuse in violation of Minnesota Statute Section 518B.01, Subdivision 14A. Based on these new crimes, DHS moved the immigration judge to reopen the withholding of removal grant, a motion that the IJ granted. The IJ then held that this new conviction for making terroristic threats constituted a particularly serious crime that made Mr. Shazi ineligible for withholding of removal under the INA and the Convention Against Torture. Importantly, the IJ relied upon the BIA's 2014 decision in matter of GGS to hold that there was no place in the particular serious crime analysis to consider Mr. Shazi's mental health issues. The IJ also found Mr. Shazi not credible and denied CAT deferral. Before we get into the meat of this, just as an aside, as the BIA's decision a year ago in the nutritious matter of Salad case shows, these crimes for making terroristic threats don't necessarily, and indeed might not ever, refer to terrorism as we usually think about it. Indeed, before matter of Salad, there was debate whether these types of crimes were even CIMTs. Just thought it worth mentioning. Anyway, back to Mr. Shazi. On appeal to the BIA, he argued, among other things, that the IJ had erred in relying on matter of GGS, because the Ninth Circuit vacated that decision on direct appeal in Gomez-Sanchez v. Sessions. The BIA rejected that argument, because Gomez-Sanchez is a Ninth Circuit case, which, according to the BIA, meant that it doesn't bind IJs sitting in the Eighth Circuit. And the Eighth Circuit reversed. Applying the Chevron deference framework, it rejected the BIA's interpretation of the particularly serious crime analysis in matter of GGS as unreasonable. This is because prior particularly serious crime case law from the Eighth Circuit and the BIA allows that, quote, all reliable information may be considered, even that which is outside the confines of the record of conviction, end quote. Accordingly, quote, the BIA's categorical ban on evidence concerning mental health issues is arbitrary and capricious, end quote. So, matter of GGS and the exclusion of mental health illnesses in the particular serious crime analysis is not good law in the Ninth Circuit, it's not good law in the Eighth Circuit, and to my knowledge has never been affirmed by any circuit. Now, the Eighth Circuit affirmed the BIA's adverse credibility finding and denial of CAT deferral, and the BIA's denial of Mr. Shazi's motion to reopen based on allegedly new evidence. But it remanded for further particularly serious crime and withholding of removal analysis. Congratulations, Mr. Shazi. But I'm still confused. Plus, I'm positively giddy on jurisdiction. I'm unclear as to why the Eighth Circuit conducted a Chevron analysis at all with matter of GGS. As the Eighth Circuit itself noted, the Ninth Circuit didn't just disagree with matter of GGS in Gomez-Sanchez. It reversed and vacated matter of GGS on direct appeal. So as a matter of law, doesn't matter of GGS no longer exist? The BIA never reissued it through another case in another circuit. So what was there for the Eighth Circuit to possibly defer to? That's the argument I've been making for years and will continue to make until some professor in the audience tells me I'm wrong. Also, big footnote on Nasrallah v. Barr, which seems to support an argument that I made just last week. In footnote 2, the Eighth Circuit said that Nasrallah's mandate that circuits review factual findings relating to the denial of CAT protection, quote, includes the factual findings underpinning the BIA's particularly serious crime determination, end quote. Put another way, even though the particularly serious crime finding also relates to withholding of removal under the INA, Nasrallah mandates that a circuit review it because it also relates to withholding of removal under the CAT. Pretty big. Furthermore, and notwithstanding the criminal alien jurisdictional bar, the Eighth Circuit in this case reviewed the factual basis for the agency's adverse credibility finding, because it too relates to cat denial. Had the Eighth Circuit reversed on that, and they didn't here, I'd say there would have been very good grounds for a motion to reopen before the BIA to readdress withholding of removal under the INA. After all, how could an adverse credibility finding possibly stand for withholding of removal purposes when a circuit court reverses it as it relates to cat protection? Makes no sense. The jurisdiction doors are opening, everyone. And that is Shazi v. Wilkinson. Next, we have Gallina v. Wilkinson, published by the Second Circuit on February 12, 2021. This is a unique case about the Convention Against Torture for a non-citizen from Italy. Judge Pooler dissented. Mr. Gallina was part of the mafia in Italy. He spent years in Italy's 41 bis prison, infamous for holding mafia members, and he spent 6 years in solitary confinement, 23 hours a day. He's currently wanted in Italy for murder. He entered the U.S. unlawfully via Canada to be with his family. Although this is a long decision, the legal issue is pretty straightforward. Does lawfully implemented prolonged solitary confinement, and a well-founded fear of future solitary confinement, equate to torture under the CAT? And IJ found that it does, relying heavily on an expert psychologist who testified to all the horrible things that prolonged solitary confinement does to the body and mind, including, in the case of Mr. Gallina, consideration of suicide. But the BIA reversed on appeal. And here, the Second Circuit affirmed the BIA. The court first recognized that indeed, quote, some sanctions prescribed by the law of a foreign state may be brutal and highly disproportionate to the penological purpose for which they are imposed, end quote, such that they might rise to the level of torture even if they are lawful in the foreign state. Nevertheless, the Second Circuit upheld the BIA's finding that, quote, there was no indication that Italian prison officials intentionally inflicted or threatened to inflict severe physical pain or suffering, end quote. The evidence in this case indicates that instead, prison conditions in Italy are designed to separate mafia members and to prevent them from interacting and engaging in further criminal conduct. Now, the CAT regulations specifically define torture in relevant part as, quote, the administration or application of mind-altering substances or other procedures calculated to disrupt profoundly the senses or the personality, end quote. Mr. Gallina argued that his experience in the 41 bis prison equated to such, quote, other procedures, end quote. But the Second Circuit rejected that argument, primarily because while Mr. Gallina clearly suffered psychological harm, quote, it is far more likely that the other procedures that the agency had in mind are discrete interventions like sleep deprivation or sensory overload through the use of bright lights, strobe lights, or recurrent loud noises, end quote. So remember those examples, everybody. Also, the Second Circuit held that Mr. Gallina's experience was not so different from similar actions taken by prison officials in the United States. And apparently, quote, no international tribunal or treaty body has found that prolonged solitary confinement, without more, rises to the level of torture, end quote. A perhaps unsurprising decision from the Second Circuit, considering our own country's similar use of solitary confinement. Here's a bit from dissenting Judge Poole. Judge Poole starts out with a bang, with quotes that can still be used to argue that solitary confinement equates to persecution or torture in other countries and under other circumstances. Quote, prolonged solitary confinement is one of the true horrors of the modern-day penal system, end quote. Quoting Justice Kennedy, Judge Poole continues, quote, years on end of near total isolation exact a terrible price, end quote. And indeed, quote, there is not a single study of solitary confinement wherein non-voluntary confinement that lasted for longer than 10 days failed to result in negative psychological effects." End quote. Judge Poole agreed with Mr. Gallina's arguments that the record showed he was subject to solitary confinement not as a lawful punishment, but in an effort to force him to collaborate against the mafia. In the end, in a statement ripe for use in future cases, Judge Poole concludes that, quote, "prolonged solitary confinement is nothing short of torture in most cases," end quote. And that is Gallina v. Wilkinson. Finally, we come to Perez-Perez v. Wilkinson, published by the 7th Circuit on February 11, 2021. Ms. Perez-Perez entered the U.S. without authorization in 1990 at the age of 18, and was placed in what was then called deportation proceedings, by being served with what was then called an Order to Show Cause, or OSC. And the OSC did not list the date and time of Ms. Perez-Perez's first deportation hearing. As was required at the time, former INS mailed a notice of hearing to Ms. Perez-Perez by certified mail, and, as is rare in these types of cases, that certified mailing was actually returned to the court with Ms. Perez-Perez's signature indicating receipt. But Ms. Perez-Perez did not appear for her deportation hearing, and was so ordered deported in absentia. 26 years later, following the Supreme Court's Pereira v. Sessions decision in 2018, Ms. Perez-Perez, presumably through counsel, filed a motion to reopen her in absentia deportation order so that she could apply for non-LPR cancellation of removal. Now, of course, non-LPR cancellation of removal is a post-IRIRA form of relief that was implemented in 1997. And which also, of course, would require that Ms. Perez-Perez show that her U.S. citizen or LPR spouse, parent, or child would suffer exceptional and extremely unusual hardship upon her removal. Bold motion, counsel. With the motion, Ms. Perez-Perez swore that she had never received the notice of her deportation hearing, notwithstanding the returned mailing that went to the court at the time with her signature. An IJ and then the BIA denied the motion to reopen. Mainly, they did so because the Pereira Supreme Court case expressly turned on the definition of a notice to appear, the document that replaced OSCs after the passage of IRIRA in 1997. Now, the Pereira case held that unless a notice to appear satisfied the statutory definition of an NTA, it would not stop the accrual of continuous physical presence required to achieve non-LPR cancellation of removal. But Pereira didn't say anything about OSCs, which of course do not have the same definition as an NTA, and indeed are not even within the IRIRA statute. And so the 7th Circuit affirmed the BIA's denial of the motion to reopen. First, it held that Ms. Perez-Perez had not shown, in light of the substantial evidence to the contrary, that she hadn't received the notice of her hearing in 1992, such that proceedings must be reopened. Then, addressing the Pereira-based arguments, the 7th Circuit dismissed them. It explained that OSCs were governed by a totally different statutory framework, making Pereira inapplicable. Quote, "As Pereira only addressed the statutory requirements of a notice to appear, the holding has no application to Perez-Perez's order to show cause." End quote. Not much else here other than some harsh language on due process and how it relates to discretionary forms of relief that should not be taken out of context, so I'll just end the episode here. And that is Perez-Perez v. Wilkinson. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.